Well, good morning. Welcome back to Deb's True Crime Notebook. Another day of documents. It looks like the judge has filed an order, and also it looks like Nick has fired back on the interlocutory. So let's see what they both have to say. State of Indiana, County of Carroll, State of Indiana versus Richard M. Allen. Order. Comes now the court, and having reviewed defendant's motion for order to shorten discovery response period, filed marked the 9th day of September 2024, now grants said motion. The 15-day notice period required by Rule 34C of the Indiana Rules of Trial Procedure on the state of Indiana is shortened to 5 days, and further directs non-party Indiana Department of Corrections to respond to said request within 7 days from the date of service, therefore. Ordered September 11th, signed Francis C. Gull, Special Judge, Carroll County Circuit Court, Carroll County, Indiana. And now let's take a look at the state's objection to certification of orders to allow for the interlocutory appeal. State of Indiana, County of Carroll, State of Indiana versus Richard M. Allen. State's objection to certification of orders to allow for interlocutory appeal. Now comes the State of Indiana by prosecuting attorney Nicholas C. McClellan and respectfully objects to certification of the court's order dated August 28, 2024 and September 4th for interlocutory appeal. In support of the objection, the state would ask the court to consider the following. 1. That on August 28, 2024, the court issued an order denying the defendant's motion to suppress statements filed April 11, 2024. 2. That on September 3, 2024, the court issued an order granting the state's motion in limine in its entirety filed April 29, 2024. 3. That the defense is now asking the court to certify those orders to allow for interlocutory appeal and delay the trial setting. 4. That under Appellate Procedure Rule 14b-1, which outline the grounds for an interlocutory appeal, it states that if the order involves a substantial question of law, the early determination of which will promote a more orderly disposition of the case, the court can certify that order for interlocutory appeal. 5. That in both the August 28th and September 3rd orders for the court, there's no question of law to be debated. The law concerning the motion to suppress and the motion in limine is well established and clear. The orders in no way involve a substantial question of law. Rather, the issues presented and decided are questions of fact. Questions of fact are appropriately determined at the trial level by the presiding judge, applying controlling law to the evidence presented and accepted at the hearing on both issues. 6. That evidence as to both issues was presented at length by the defense, that the defense was not able to meet its burden on the suppression issue or in any of the issues outlined in the motion in limine concerning third-party motive, geofencing, or any other topic outlined in the motion, that the burden of the defense is well established by law in both of these areas. 7. That the defense has not shown that the orders from August 28, 2024 or September 3, 2024 contain a substantial question of law. 8. That an interlocutory appeal would delay the trial for a second time. That a delay of a long, complex trial so close to the start date is burdensome on the state and on the family of the victims, as well as financially burdensome on the county. 9. That given the fact that the law is so well established in these areas, there is a high unlikelihood of a different outcome at the appeals level. 10. Therefore, the burden on the state, the families of the victims, and the county of continuing a long, complex trial so close to the start date is greatly outweighed by the limited chance of a different outcome in an interlocutory appeal. 11. That the motion to certify the orders for interlocutory appeals should be denied. 12. That this filing should be shown as a waiver of the 15 days permitted for any response as set forth in Appellate Procedure Rule 14b-1d, and no additional response will be submitted. Wherefore, the State of Indiana, by prosecuting attorney Nicholas C. McClellan, respectfully requests this court to deny the motion for the defendant to certify the orders for interlocutory appeal. Further, the state would ask the court to maintain the current trial dates and for all other relief just and proper in the premises. And it's signed Nicholas C. McClellan, attorney number 28300-08, prosecuting attorney. And so now we wait for a reply on the interlocutory appeal by the judge. And as I understand it, she can take up to 30 days to make that reply. And if there is no reply in 30 days, then it is considered denied. So we'll see you next time on Deb's True Crime Notebook. Don't forget to like, share, subscribe, ring the bell for notifications, and leave us a comment. Have a great week.